pillar of the legislative moves. As part of that also, there's been this kind of sense that you have to have a lot of safeguards in place to protect that voluntary choice. So if we start looking at, so if we look at definitions, we always find this sort of thing. Medically assisted quick peaceful death at the request. So I've italicized the at the request, and that appears in those first three definitions there. Then if you go down to that last one there's something slightly different introduced, and that is the idea that euthanasia can be by act or omission. And I think that that's certainly comes up regularly as a point of contention. Not everyone will accept that kind of definition, but regardless, the centrality of the voluntary choice is always there at the very start. So what I just wanted, before I sort of unpackage the main purpose of the paper, which is essentially to explore mainly what the evidence is that we have so far about the significance of choice in regimes where euthanasia or assisted suicide are enacted and happening. But before doing that, I just wanted to say a couple of things here, because I think this frames things if we talk about the justification for euthanasia and the interplay, if you like, between suffering and autonomy. So the first thing, which I think is a fair comment, is that suffering remains the primary justification for euthanasia. There's no point in really thinking about it outside of the context of suffering. But very quickly we find that that is conditioned by autonomy, that the patient is the one who has the say about their suffering, what it's like, and of course suffering being that type of thing which is very complex and individualized, physical, psychological, existential, all elements of it can have a very individual aspect. So that's, I think, why the sort of the entry point where we find where we find autonomy and suffering joining. But then, for some reason or other, we find this transition happening fairly quickly, that people without capacity or compromised capacity then come into the equation. And then suffering is that as perceived by others. Because if you've got someone who can't choose or has a compromised choice, then someone else has to make that kind of decision. And I think it's universally fair to say that most people would agree that euthanasia and assisted suicide are those types of decisions for which a very high standard is required. I don't think anyone would argue that that's not true, but unfortunately when it comes to practice, something different happens. I want to actually add one last thing here about the justification for euthanasia, and I think this is the sort of thing which has dropped off the radar. People don't want to think about this aspect of the justification, but I think it's there, and that is the relief from human brokenness, if I can put it that way. That the kind of suffering we're talking about is often associated with burden, with disability, with the types of things that we would not want to endure, understandably, when we don't want to see other people endure them. But then there's this other aspect that it could even go to a disdain for human brokenness. And I think that's something which has the potential to drive the categories of decision making that are where capacity is compromised or absent. But it's certainly not the sort of thing which anyone wants to talk about up front. So this first category, which I wanted, there are three main areas that appear in the paper. The first one is non-voluntary euthanasia. So by definition, that being euthanasia where the person has not been able to make an informed choice. And the second category where choice is compromised, and there are three main areas which I've looked at, which are minors, people under the age of 18 or 16, depending on the legislature, people with dementia, and then mental illness, psychiatric cases. So those three categories fall into that compromised decision-making group. And then finally, the somewhat more nebulous area of influence, coercion, and pressure, which I think are the types of things which form cultures around euthanasia. But just as a kick-off point, infant euthanasia is certainly happening, and we can use it as an example of some of the problems we have getting to the bottom of things, because most people will be familiar with the Groningen Protocol in Holland, and that 3 cases per year in the 90s and early 2000s were reported. And yet Verhagen, and I don't know how to pronounce it, so I'm not sure, in 2005 said that there were more likely 15 to 20 cases per year. So that's a reporting incidence of about 20%. So that's very low. But then survey and death certificate analysis revealed something similar, about 10 to 15 cases. But interestingly, that was 10 to 15 cases per year for infants not on life support, and a further 80 to 100 on life support. Okay. Now those 80 to 100 were not considered to be euthanasia, even though a lethal injection was involved. Approximately 2/3 of those infants had a life expectancy of less than 1 month, and 1/3 of them had life expectancy of more than 1 month. So we're clearly talking about euthanasia, lethal injection, active euthanasia. But once you start adding up those numbers, 10 to 15 cases, 80 to 120, you're really in a much, much bigger territory than the 3 cases per year, or more recently, around 2010, 2 cases reported for a 5-year period. Now here in Australia, this particular figure, 2 cases reported for 5 years, is usually used to dispense anyone's suggestion that infant euthanasia is an issue. It's so rare, is the suggestion. There are various reasons why people think that that might have been, the survey cases revealed about 6 cases in 2010, 6 being those on life support, none that were not on life support. So that's 80 to 120 down to 6. So it's a huge change. And there have been various reasons suggested for why that might be the case. We'll leave that for the moment. Moving on to the category which most people seem to think about when we talk about the failure of informed consent is ending of life without patient's explicit request. Now that's in all of the major reports coming out of Holland, this category has been maintained, so that in 1990 it was 0.8% of all deaths and 0.3 in 2015. So the idea being that it looks like non-voluntary euthanasia of adults has declined over time. But I don't think that's actually accurate. And the reason I don't think it's accurate is that back in 1990, there was also a category called opioids in large doses, which was changed in 2001 to intensified alleviation of symptoms. And that category has gone from 18% to 35%. But in the reports, we don't have information in the latter years about explicit intention to terminate life, and certainly not whether there was a patient's request. But in the earlier years, we did have evidence that a significant number of those opioids in large doses cases were with an explicit intention to end life. Okay, but we don't know all the way along what the patient consent was. So this is part of the problem with the reporting. We don't know. But having said that, there are several other reasons why there's good evidence to suggest that a significant number of those would have been without consent. So they would have actually fallen within non-voluntary euthanasia of adults. We just don't know how much. Herbert Hendon, way back in the early days of the 90s, suggested that of the 6,000 deaths, which is the euthanasia ones, plus others in this ending of life without explicit request, about 40% of them were without consent. So that makes a figure much bigger. It's probably around the 2,500 cases without consent, bigger than this 0.8 figure here for 1990, which is about 1,000 people. So to sum that up, it may well be the case that within these categories, opioids in large doses, then terminology changed to intensified alleviation of symptoms, we have many cases of non-voluntary euthanasia. Belgium is something similar. So moving along from the overt category of failure to informed consent, there are three, as I mentioned at the start, categories of patients for whom one could say there's a compromised choice or a deficient capacity. Minors, dementia patients, and psychiatric patients. So I'm just going to say a little bit about dementia patients to try and get some handle on the incidence. As I said at the start, I'm mainly trying to look at evidence base here. We know that there were 12 cases in Holland in 2009, and that has risen to 169 cases by 2017. So that in itself is a large climb. But interestingly, whilst there are very large numbers of advance directives of people who have dementia, some authors suggest that that's rarely honoured. And so in these particular cases, they were all deemed competent. So that kind of suggests that dementia patients, only the ones who are competent or deemed competent, are actually being euthanized. But there's other evidence to suggest that that's not necessarily the case. There's quite a bit of uncertainty in the literature about the adherence to an advance directive. But even advance directives aside, euthanasia of dementia patients when incompetent seems to be happening certainly in Belgium. There are a couple of papers which describe a rather high incidence of patients within the category, the use of life-ending drugs without an explicit request from the patient, who were dementia patients. And I would take that, without it being explicitly said in the articles, take that as that those patients were not in a position to request. Otherwise, they would have just fallen within the normal euthanasia category or within this top group of the 169 or whatever, or the equivalent in Belgium. So the numbers, again, what we know, and this larger, I think, potentially larger category of those we don't know the actual numbers of, we know that they're there. We do know that from a survey of Canadian doctors, 43% would euthanize a patient with terminal dementia and without an advance directive. So we certainly know the will is there amongst Canadian doctors at least to euthanize patients without a request, dementia patients. There's an interesting conundrum that comes up with the relationship between dementia and assisted suicide, because if that becomes the type of case where assisted suicide is permitted, then you wonder how on earth it would work in practicality, because a patient with early stage dementia may request medication for assisted suicide, take it home, keep it, and then at some point of time, they or someone else would decide about its use. And that leaves, well, it's a general problem with assisted suicide as it is, leaving potent medications in potentially unsecured locations. But it does mean that those particular people, as their dementia advances, have access to medications for terminating life, but we don't know what state they necessarily might be in when they use that. So if the argument does extend from euthanasia to assisted suicide, as far as dementia goes, it does raise some really curly questions. Moving on to psychiatric patients, my personal feeling is that this is one of the leading edges. It's certainly something that's happened frighteningly fast in Canada. Whilst the numbers are small, in Holland there were no reported cases in 2008, and then 83 by 2017. The majority were women, We do, I think, fairly expect that there's been underreporting, as there has with most of the data. But we do also know that there were 1,100 requests for psychiatric euthanasia in 2015, so the demand is there. Of course, most of those appear to have been denied. It's interesting, just recently, I occasionally go to a blog site in the Euthanasia Prevention Coalition in Canada, Alex Schardenberg, and he's reported several anecdotal accounts, plus newspaper reports of interviews with medicos who have been carrying out psychiatric euthanasia in Canada, even though it's not yet legal, but all things are pointing in that direction. There seems to be a significant disagreement among physicians, specialists and psychiatrists about capacity to consent for psychiatric patients. And I think that gives voice to the uncertainty about things like treatment, the episodic nature of mental illness. And I don't really then find it surprising that specialists are going to disagree. If that's the case, it does mean that with someone like a psychiatrist or psychologist who has much more knowledge of a particular mental illness might make a reasonable judgment about capacity. I'm not sure that physicians are necessarily in that sort of position of knowledge or awareness to make those kind of judgment calls. And yet that's precisely what they would be doing. And I believe that in Holland, the end-of-life clinic, a specific clinic set up to deal with euthanasia cases, handles about 60-odd% of the psychiatric cases. So it's a dedicated clinic. But I couldn't find anything about the level of professionalism about capacity determinations regarding the end-of-life clinic. 86% of psychiatric nurses agree with psychiatric euthanasia, but more than half of them were uncertain about the decision-making capacity or thought it might be absent. So I would have thought that psychiatric nurses would be in a pretty good position, being close to patients and dealing in a caring capacity for psychiatric patients, that they would have some reasonable understanding of decision-making capacity, and they themselves are uncertain about it for a large number of those cases. Okay. So the first group I talked about was the clearly where consent is absent. The second, where it's compromised. And now this is the territory of coercion and pressure and influence and, sort of, I suppose you could still say it's somewhat in the territory of compromised choice. I'm aware that with this whole subject, one of the comebacks could be that we're starting to talk about the types of pressures and influences which bear on everybody in all of their decision making. But nevertheless, I would revert back to the kind of justifications put forward for voluntary euthanasia that suggests that it's the type of decision making which demands an extremely high standard. And so because of that, issues of pressure and coercion, certainly in the 15 pieces of legislation which came before this state, were all about protections to guarantee that voluntary choice, to make sure that people weren't coerced in any way, to make sure there was no pressure. So this is one of those areas which is again, a small category of euthanasia, but in Canada, for example, has been rapidly expanding. So there were 30 donors over a 3-year period, but then there were 18 in Ontario alone for 2019. That's all I could find. But that suggests a fairly rapidly increasing incidence. And I think one of the trickier parts of combining organ donation with euthanasia is that the sort of stalwart the ethical standard of the dead donor rule, which requires that the patient be certified brain dead before organs are removed, is the very thing which would be first to go in cases of euthanasia combined with organ donation, because the dead donor rule has, ethicists have been bothered about that for some time as a real hold up to getting good quality organs, because people come in and you can be as quick as you like, but you could never be as quick as if in a case of euthanasia, you're actually terminating the person's life by the removal of the organs. That is the best way to harvest the best quality organs. So I think that there's a potential pressure coming from the presence of euthanasia to modify the dead donor rule, and that certainly comes up regularly in ethics discussions about organ donation. The other thing which is probably more pertinent to the business of influence and choice is the difficulty in separating the decision for euthanasia from the decision to donate organs. Typically in the literature, this is handled by saying they must be separate. They must be completely separate. No one should raise the question of organ donation for someone talking or inquiring about euthanasia. I personally don't think that's in the slightest bit realistic. People have a high level of knowledge about the business of organ donation. They are, in their decision-making process about euthanasia, also confronted with people who think, and these are people in the health professions in Canada, for example, who think that it should be raised, organ donation should be raised in the context of euthanasia, should be part of the discussion from the word go. Now, if that's the case, my personal view on that is that it does actually potentially work as an element enough to sway a decision that someone in a vulnerable situation may be making about the possibility of euthanasia, if the thought and the encouragement that great good can come by the donation of organs may be sufficient to sway a decision. So I would say that's a significant pressure. So that's organ donation. Then in the territory of burden and disability, a colleague of mine, Nick Tonti Filippini, was a bioethicist, Australian bioethicist who passed away a few years ago, and he, at the time that we had some of this legislation in South Australia, he wrote a rather poignant letter to the MPs about not needing any encouragement to feel like a burden, because he acutely felt like a burden. He had a lot of health issues. He acutely felt like a burden as it was. And he believed that the issue of burdensomeness, internalised, was a very powerful factor in people's decision-making at the end of life, and that if the option for euthanasia were there, it would be the type of thing which would be a significant pressure for people towards euthanasia. And I think he had a lot of backing for that, because there's certainly plenty of research that to suggest that a self-perceived burdenness, it does rate highly in people's justification for the desire to seek euthanasia and assisted suicide. They perceive themselves to be a burden, whether that's correct or otherwise. In certain situations, there'll be some unpleasant circumstances where they may be made to feel a burden. And of course, some may recall that famous quote from Mary Warnock, where she said that you are a burden on the resource of the NHS and on your family members, and you have a duty to die. Which is interesting to say duty to die in the context of euthanasia, because there was a sort of an easy flow from duty to, so she said, allowed to die, and then a duty to die in the context of euthanasia. So it was a sort of a strange flow of statement. Elder abuse is one of those problems that has certainly come to light here in Australia. I don't know about the UK, but we've had a lot of research done here recently, and various government inquiries, and it is a problem which no one perceived that the magnitude was what it was. And I think that in the context of elder abuse, people's lives, a small number hopefully, can be made to feel so miserable by the abuse that the option of assisted suicide or euthanasia suddenly becomes more attractive than it otherwise would be, if I put it in that way. Moving on to disability, and I think I better move fairly quickly because I'm probably drawing close to the end of time. I did want to say that I think that there's a real discordance between the way that in recent years most Western democracies have seemed to deal so well with disability. Here in Australia, we've had a major insurance program, government program for disability so that people can be cared for. We have that kind of high level of awareness and appreciation of people with disabilities. But if I can use abortion as an example, abortion for youth disability is the most supported category for justification of abortion. So the people in the disability community are aware of that, and they also say that despite all of the public awareness, people are still not necessarily aware of what their lives are really like, and a lot of the difficulties they face. And a lot of those difficulties constitute the kinds of things which act as influences and pressures over them. And this is a quote from Gill in 2010. She said, if requesters of assisted suicide die believing that their only options are a nursing home, the degrading imposition of their intimate needs on family, taking their chances on the help of strangers or death, how is that voluntary? So I think what she's talking about is the real lived experience of people with a disability and what that means when this option becomes available, and that effectively means that choices are constrained. I'm sort of loath to mention this, but the cost of care is the elephant in the room that no one really talks about much, but I wouldn't deny that it's a factor, and I do think it's a factor. And it's not so much a factor for negatively influencing the capacity of an individual to make a free choice, but it's the kind of thing which has more influential power at political level in the kind of decision-making processes that go on there. So no one is probably brave enough to say at that kind of in a political sphere that something like euthanasia and assisted suicide will be cheap compared with other forms of care, but everyone knows it's true. And finally, and I'll just move fairly quickly through culture and expectation. I think the primary question, of course, is common sort of thing, is what kind of culture we want for end of life. And I say elsewhere because euthanasia has shifted into the territory of elsewhere, not just the end of life. And that's certainly true of the Dutch current toying with the idea of tired of life or completed life, that for those over the age of 70, there would be an option for euthanasia. In a survey of those who might consider it as a choice, what was found was that most were driven by the absence of being visible, recognised, wanted, needed, valued, or depended upon, or attended to by others. Now, if that's not a definition of vulnerable people, I'm not sure what is, but over the age of 70, I'm getting close to that. And it's kind of a sobering thought that this kind of, cultural pressure could exist one day. If it's on the cusp in the Netherlands, and what's happened in the Netherlands starting, 30, 40 years ago, has made a impact elsewhere in the world, it may not be too far-fetched to think that this sort of category of euthanasia case, if implemented there, could also be considered elsewhere. what I find particularly disturbing is the speed with which Canada has moved. So Canada has moved from 2016, enabling euthanasia, building in at that time a process for examining euthanasia for minors, for dementia cases through advanced directives, and for psychiatric patients. And now, at this very moment, just 4 years later, considering it seriously. And as I said before, some psychiatric cases anecdotally having already occurred. That's very rapid. And of course, I can never pronounce that name. Such a culture, euthanasia culture, would increase social pressure on older people and reinforce negative ideas surrounding old age. And so, as I said before, I think these are the two of the leading edges. So to sort of sum up, if you look at the trajectory over the last 30 or 40 years of euthanasia and assisted suicide and how things have shifted and changed, I think it's a fair observation to say that we've moved more in the direction of limiting choice, or into categories of patients, put it this way, categories of patients for whom choice is limited and somewhat compromised. And if that's the case, then right back at the start, when we're talking about suffering and autonomy, then autonomy is useful for framing the early stages of a movement. But then, because I think possibly that last point I made on the very first slide, which was a disdain for human brokenness, takes greater precedence as time goes by.